Hello and welcome back to Droanacharya IAS YouTube channel. You're watching daily editorial analysis covering 14th May 2022. इस वीडियो लेक्चर में हम आज के इम्पॉर्टेंट एडिटोरियल्स कवर करेंगे. This includes Uniform Civil Code and the issue of marital rape. So let's begin with it. So let's begin with the issue of Uniform Civil Code. So there's an article in Indian Express today which is written by Tahir Mahmood. The title of this editorial is How to Frame the Uniform Civil Code. So this entire topic becomes important from GS point of view, GS2 paper. Prelims as well as mains, both are concerned. Article 44, Article 25, Article 14. These are important from prelims point of view. If we talk about its relevance from mains point of view, the implication of Uniform Civil Code on personal laws, this issue is important. So we'll cover this entire editorial. Also recently एक PIL जो कि 2019 में फाइल की गई थी, उसके रिस्पॉन्स में रिसेंटली भी इवन मिनिस्ट्री ऑफ लॉ एंड जस्टिस ने रिस्पॉन्ड दिया एंड सेड दैट द इम्प्लीमेंटेशन ऑफ यूनिफॉर्म सिविल कोड इट इज़ अ डायरेक्टिव प्रिंसिपल अंडर आवर कॉन्स्टिट्यूशन. हमारा आर्टिकल 44 यूनिफॉर्म सिविल कोड से डील करता है एंड इट इज़ अ मैटर ऑफ पब्लिक पॉलिसी एंड दैट नो डायरेक्शन इन दिस रिगार्ड कैन बी इशूड बाय द कोर्ट. ये एक पॉलिसी का मैटर है, कोर्ट इस रिगार्ड में कोई डायरेक्शन नहीं दे सकता. एंड इवन सेंटर हैज़ रिक्वेस्टेड द लॉ कमीशन ऑफ इंडिया, रादर 21st लॉ कमीशन ऑफ इंडिया, to undertake the examination of various issues that relates to Uniform Civil Code and to make recommendations thereafter. तो यूनिफॉर्म सिविल कोड की अगर हम बात करें, इससे बेसिकली पूरे कंट्री के लिए there would be one law for the entire country and that one law will be applicable to all the religious communities in their personal matters like marriage, divorce, inheritance, adoption, etc. तो पूरे कंट्री के लिए for all the religious communities there would be one law. This is called as Uniform Civil Code. And Article 44 of our Constitution lays down that state shall endeavour to secure a uniform civil code for citizens throughout the territory of India. लेकिन Article 44 एक DPSP है. DPSP मतलब Directive Principle of State Policy. एंड आप पॉलिटी में जब DPSP पढ़ते हो, यू नो दैट DPSPs आर नॉट जस्टिफाइबल. इट मीन्स दैट दे आर नॉट इन्फोर्सिबल बाय एनी कोर्ट, रादर दीज आर प्रिंसिपल्स विच आर लेड डाउन विच आर फंडामेंटल इन गवर्नेंस. तो आर्टिकल 44 जो कि यूनिफॉर्म सिविल कोड की बात करता है, ये एक DPSP है और ये नॉन जस्टिफाइबल है, जिसे कोर्ट एनफोर्स नहीं कर सकती. दीज आर पॉलिसीज ऑफ विच आर फंडामेंटल in governance. Then let's understand what is the status of Uniform Civil Code in India, rather Uniform Codes in India. See, India की जो laws हैं, they follow Uniform Code in most of the civil matters like Indian Contract Act, 1872, Civil Procedure Code, then Transfer of Property Act, Partnership Act, Evidence Act. तो mostly India के जो laws हैं, they do follow the Uniform Code. But states have made hundreds of amendments and therefore in certain matters there is diversity even under these secular civil laws. Like recently जो Uniform Motor Vehicles Act 2019 का था, बहुत सारी states ने refuse किया that they will not be governed by this Uniform Motor Vehicles Act. So कुछ जो uniform जो secular हमारे पास जो laws हैं, उनको भी यहाँ पे different amendments करके अलग अलग नेचर में हर एक स्टेट अपने मैटर के हिसाब से इन्हें गवर्न करती है. नाउ यूनिफॉर्म सिविल कोड की बैकग्राउंड को अगर हम देखें तो इसका जो ओरिजिन है इट गोज़ बैक टू दी कॉलोनियल इंडिया, जब ब्रिटिश गवर्नमेंट ने अपनी रिपोर्ट 1835 में सबमिट की थी, जिस रिपोर्ट में स्ट्रेस दिया गया था दैट देयर इज़ द नीड फॉर यूनिफॉर्मिटी इन द कोडिफिकेशन ऑफ इंडियन लॉज. Laws related to crimes, evidence, contracts, especially recommending that the personal laws of Hindus and Muslims be kept outside such codification. तो पर्सनल लॉज को तो पहले से ही इस जो कोडिफिकेशन की जानी थी, यूनिफॉर्मिटी जो देने वाले थे, इसमें पर्सनल लॉज जो हिंदूज और मुस्लिम के थे उनको पहले ही बाहर रखा गया. सो इंक्रीज इन लेजिस्लेशन डीलिंग विद पर्सनल इशूज़ in the far end of British rule forced the government to form B.N. Rao Committee to codify Hindu law in 1941. 1835 में तो उनको पर्सनल लॉ से कोई वो नहीं था. They were mainly talking about crime, evidence, contracts. बट जैसे जैसे उनकी पर्सनल इश्यूज़ के साथ लेजिस्लेशन बढ़ रही थी तो उस टाइम पे ब्रिटिशर्स ने B.N. राव कमेटी बनाई विच वॉज टू कोडिफाई हिंदू लॉ. So based on these recommendations, a bill was then adopted in 1956, which is Hindu Succession Act, which was to amend and codify the laws which are related to the in-state or unwilled succession among Hindus, Buddhists, Jains and Sikhs. However, there are separate personal laws for Muslim, Christian and Parsis. So in order to bring the uniformity, courts ने अपनी different judgments में ये कहा है that government should move towards uniform civil code. Like for example, the judgment of Shah Bano case is well known. There's another case of Sarla Mugdal case, which dealt with the issue of bigamy and conflict between the personal laws and the existing matters of marriage. So by arguing the practices like triple talaq, polygamy, सो ये जो राइट ऑफ विमेन है टू लिव देयर लाइफ विद डिग्निटी, ये इसे एडवर्सली इम्पैक्ट करते हैं. तो सेंटर ने ये क्वेश्चन रेज किया दैट वेदर देयर इज कॉन्स्टिट्यूशनल प्रोटेक्शन गिवन टू रिलीजियस प्रैक्टिसेस शुड एक्सटेंड इवन टू दोज दैट आर नॉट इन कंप्लायंस विद फंडामेंटल राइट्स. तो ये एक काफ़ी हॉट डिबेट रही थी व्हेन वी वर टॉकिंग अबाउट ट्रिपल तलाक एंड पॉलीगैमी इश्यूज़. एंड नाउ जो मोस्टली जो इस आर्टिकल में भी दिया गया है, what is most important is to understand the implication of Uniform Civil Code on personal laws. See, Uniform Civil Code की अगर हम implication की बात करें तो पहला यहाँ पे पॉइंट आता है the protection of vulnerable section of the society. जो हमारी सोसाइटी में जो vulnerable section है ये उनको एक प्रोटेक्शन प्रोवाइड करता है. This was envisioned by Dr. Ambedkar, which includes women, religious minorities. एंड इससे जो नेशनलिस्टिक फर्वर की जो फीलिंग है थ्रू यूनिटी ये प्रमोट होती है. एंड देन दिस विल लीड टू सिंप्लीफिकेशन ऑफ लॉज. ये जो कोड है जो अभी कॉम्प्लेक्स लॉज हैं व्हेन इट कम्स टू मैरिज सेरेमनीज, इनहेरिटेंस, सक्सेशन, अडॉप्शंस, उन सब के लिए अगर एक लॉ आ जाता है तो ये जो कॉम्प्लेक्स लॉज हैं उनको सिंप्लीफाई कर देगा. सेम सिविल लॉ हर एक सिटीज़न के ऊपर अप्लाई होगा इररिस्पेक्टिव ऑफ देयर फेथ. So obviously simplification of law will happen. Then adhering to the ideal of secularism. Now see, secularism is something which is enshrined in our preamble as well. तो जो secular republic है, it needs a common law for all citizens rather than laws which are differentiated based on their religious practices. अगर यूनिफॉर्म सिविल कोड इनैक्ट होता है तो जितनी भी अभी पर्सनल लॉज हैं they will cease to exist. तो जो भी एग्जिस्टिंग लॉज में जो जेंडर बायसेस हैं वो ख़त्म हो जाएंगे एंड इससे जेंडर जस्टिस भी आ पाएगा. बट देन देयर आर चैलेंजेस एज वेल. देयर आर एक्सेप्शंस इन द सेंट्रल फैमिली लॉज एज वेल. अगर हम प्रीलिमिनरी सेक्शन की बात करें, जितने भी हमारे सेंट्रल फैमिली लॉज जो एक्ट्स हैं विच आर इनैक्टेड बाय द पार्लियामेंट सिंस इंडिपेंडेंस, दिस डिक्लेयर दैट दे विल अप्लाई टू द होल इंडिया एक्सेप्ट द स्टेट ऑफ जम्मू एंड कश्मीर. एक तो एक्सेप्शन यही है. देन सेकेंड एक्सेप्शन वॉज एडेड इन 1968 दैट इन ऑल दीज एक्ट्स प्रोनाउंसिंग दैट नथिंग हेयर इन कंटेन शेल अप्लाई टू दी रिनोनकैंस इन यूटी ऑफ पुडुचेरी. पुडुचेरी में जो रिनोनकैंस हैं उनके ऊपर ये अप्लाई नहीं होगा. थर्ड एक्सेप्शन आ जाती है कि नन ऑफ दीज एक्ट्स अप्लाइज इन गोवा एंड दमन एंड दीव. फोर्थ एक्सेप्शन आ जाती है अबाउट नॉर्थ ईस्टर्न स्टेट्स ऑफ नागालैंड, मिजोरम, स्पेशली आर्टिकल्स लाइक 371A, 371G of our constitution. And then there is issue of communal politics as well. The demand for a uniform civil code has been framed in context of the communal politics. there's a large section of society that see it as majoritarianism under the grab of social reform. तो कॉन्स्टिट्यूशन हर्डल भी है. आर्टिकल 25 की अगर हम बात करें, इट सेज दैट it basically seeks to preserve the freedom to practice and propagate any religion. So this gets into the conflict of the concept of equality which is enshrined in Article 14. Article 14 की जो यहाँ पे equality की हम बात करते हैं, ये उसके साथ conflict में आ जाता है. So if we talk about the way forward, the government and society will have to work hard to build trust, but more importantly make common cause with social reformers rather than religious conservatives. Instead की एक omnibus approach लेकर government could bring separate aspects like marriage, adoption, succession, maintenance into uniform civil code in stages, धीरे धीरे करके. The need of the hour is codification of all the personal laws, ताकि जो भी prejudice हैं, जो भी stereotypes हैं, in every one of them this should come to the light and this should be tested on the anvil of fundamental rights of our constitution. आगे बढ़ते हैं. हमारा next editorial is about the issue of marital rape. The title of this editorial is A Question of Consent. It is written by Mary E. John. So recently, the marital rape, this is in news as the two-bench judge of Delhi High Court has delivered a split verdict in a batch of petitions which were challenging the exception that was provided to the marital rape under section 375 of IPC. So one of the judges held that the exception was unconstitutional, while the other judge said that the provision is valid. तो जिसके बाद इस जजमेंट ने दोबारा इस डिबेट को इग्नाइट कर दिया है दैट डील्स विद द क्रिमिनलाइजेशन ऑफ मैरिटल रेप इन इंडिया. तो इस आर्टिकल से मेन टेक अवेज लेते हैं. विल अंडरस्टैंड व्हाट इज़ मैरिटल रेप, व्हाट इज़ द करंट स्टेटस इन इंडिया, व्हाट इज़ द मैग्नीट्यूड ऑफ मैरिटल रेप, ग्लोबली क्या स्टेटस है, देयर आर सम प्रोमिनेंट केसेस related to this, and then we'll see the arguments that why should marital rape be criminalized or what are the challenges with the criminalization of the marital rape. Let's discuss it one by one. तो सबसे पहले अगर हम बात करें what is marital rape. See, marital rape is also called as espousal rape. It is basically the unwanted intercourse by man on his wife which is obtained by force, threat of force or physical violence, or when she is unable to give consent. The words are unwanted intercourse. It refers to all sorts of penetrations against her or without her consent. The consent is important. So if we talk about the current status of the marital rape, so in India the definition of rape is under section 375 of IPC. इंडियन पिनल कोड का सेक्शन 375 रेप की डेफिनेशन से डील करता है एंड दिस डज नॉट इंक्लूड मैरिटल रेप एज अ क्रिमिनल ऑफेंस. सो देन कम्स इन क्वेश्चन एक्सेप्शन टू द सेक्शन 375. तो सेक्शन प्रोवाइड क्या करता है? दिस सेक्शन प्रोवाइड्स दैट द सेक्शुअल इंटरकोर्स बाय अ मैन विद हिज ओन वाइफ प्रोवाइडेड that the wife is over the age of 18 would not amount to offense of rape. So this is based on the premise that all sex within marriage is consensual. It is perpetual consent. तो ये जो exemption है ये allow करती है that it's a marital right to a husband who can with legal sanction exercise his right to consensual or non-consensual sex with his wife. मैरिटल रेप को सिर्फ और सिर्फ डोमेस्टिक वायलेंस की जो डेफिनेशंस आती हैं वहाँ पे कवर किया जाता है. इट इज़ डिफाइंड अंडर द प्रोटेक्शन ऑफ विमेन फ्रॉम डोमेस्टिक वायलेंस एक्ट 2005. एंड जो डोमेस्टिक वायलेंस एक्ट है ये एक सिविल लॉ है. इट ओनली प्रोवाइड्स फॉर सिविल रेमेडीज टू द वाइफ. अंडर सेक्शन 376A ऑफ IPC 1860, rape of judicially separated wife was criminalized. However, जस्टिस वर्मा कमेटी जो कि 2012 में कॉन्स्टिट्यूट की गई थे, दे स्ट्रांगली रिकमेंडेड दैट दे शुड बी एक्सेप्शन अंडर IPC. जो एक्सेप्शन है कि जो सेक्शुअल इंटरकोर्स विद अ मैरिड वाइफ, इट इज़ नॉट अ रेप, इस एक्सेप्शन को रिमूव करना चाहिए. Now the next question comes that what is the magnitude of marital rape in India? See, there was a survey which was conducted by International Center for Research on Women 2011. And according to the survey, nearly 20% of Indian men have reportedly at least once carried out sexual violence against a female partner. Then there is another study by National Health and Family Survey, NH, the fourth round, जिसमें 2015 and 16 कवर किया गया था. According to it, 5.6% of women has been reported as victims under the category of physically forced her to have sexual intercourse with husband even when she did not want to. And then जो recent National Family Health Survey आया है, 5th round की रिपोर्ट में देखा गया था 30% women in the age of 18 to 49 years has experienced physical violence since the age of 15 years. 6% have experienced sexual violence in their lifetime. Even when 6% women who have admitted to sexual assault, 80% women have said that the perpetrator is their husband. So the marital sexual violence is widely prevalent in India. Then comes what is the global status regarding the criminalization of the marital rape. See, जो marital rape immunity है, it is known to several post-colonial common laws countries. लेकिन ऑस्ट्रेलिया में 1981 में, कनाडा में, साउथ अफ्रीका में, यहाँ पे ऐसे लॉज इनैक्ट किए गए जिससे कि मैरिटल रेप को क्रिमिनलाइज किया गया. सिमिलरली यूके में भी 2003 में मैरिटल रेप को आउटलॉ किया गया. एंड देयर आर मोर देन 150 कंट्रीज जिन्होंने मैरिटल रेप को क्रिमिनलाइज कर चुके हैं बाय 2019. तो ग्लोबली भी ये एक इम्पॉर्टेंट इशू है और कंट्रीज मैरिटल रेप को क्रिमिनलाइज कर रहे हैं. Now after this comes, what are some prominent cases that are associated with the marital rape. तो जो सेक्शन 375 है, इसमें जो एक्सेप्शन 2 है, it is also challenged before Gujarat High Court on the grounds that it undermines the consent of women based on marital status. Similarly, Karnataka High Court में भी recently marital rape charges को लेकर allow किया गया था against a man despite the exemption in the law. बेशक exemption थी but still marital rape charges लगाए गए थे. There is an important case, निमेश भाई भारत भाई देसाई versus State of Gujarat. So in this case, Gujarat High Court elaborately dealt with the issue of marital rape, and the court stated that making marital rape an offence will remove the destructive attitude that promote the marital rape. However, due to the non-recognition of the marital rape as a crime, the court held that the husband is liable only for outraging her modesty and unnatural sex. Then there is also Independent Thought versus Union of India case. In this case, Supreme Court criminalized the sexual intercourse with a minor wife, which is aged between 15 to 18 years. But again, Supreme Court refused to delve into the question of marital rape of adult women while examining the exception to section 375. तो यहाँ से क्वेश्चन आता है that why should marital rape be criminalized? See, first of all, अगर हम marital rape abuses की बात करें, it abuses, it humiliates, it degrades, it violates the dignity of women, thereby undermine their bodily integrity, and it violates Article 21, which is right to life. Secondly, it is against the right to equality as well, Article 14, because it is applied in different criminal provisions on women based on their marital status. Also, if husband is accused of gang rape of his wife, then he will not be punished, thereby undermining equal treatment of between all the accused persons. So it is a severe form of sexual violence that is punishable in many civilized society, and it is a symbol of gender justice. Decriminalizing the marital rape simply means concretizing this patriarchal mindset in the society, under which husband believe that wife is their property and they can do anything with them. The civil remedies for the marital rape includes protection order, judicial separation, monetary compensation. Thus, the 2005 Act only provides a recourse to women to remove themselves from the violent and dangerous situation. And it does not do anything to deter with the violent behavior of husbands. Giving immunity to marital rape, it erodes the women's power to negotiate the contraception, to protect themselves against the sexually transmissible diseases, and to seek environment of safety. And it has a deep psychological impact on the victim women. According to one study, women victims of marital rape are twice as likely to experience depression. But there are some challenges also. Challenges हैं, तभी marital rape को जब criminalization की जब बात आती है तो काफ़ी flame उठती है यहाँ से. Some experts believe that the institution of marriage is the sacrosanct in society and it needs to be upheld at all the cost. And all the procreative sex within the marriage is legitimate. It further increases the threat to women's life by her husband and her in-laws. Any attempt to go against them may lead to further atrocities and attempt on her life. Dissatisfied, angry, vengeful wives might change they can charge their innocent husbands with false cases of marital rape. And it would be difficult for husbands to prove their innocence. There are issues, because these crimes are committed in a space where there are no eyewitnesses. But this is the same for other crimes as well, the other crimes of rape and POSCO. So what lies ahead? See, even though the court has delivered a split verdict, its intervention moves the needle in favor of doing away with marital rape exemption in law. There is one judge of opinion takes the conservation forward on the subject and sets the stage for larger constitutional intervention before Supreme Court. Article 142 grants exemption to the power of Supreme Court. Under this, Supreme Court has equivalent power of lawmaker. So in failure of any parliamentary legislature, the courts can strike down the exception to section 375. This is important. Article 142 is important. Secondly, the laws alone cannot be used to fight the marital rape issue. Societal change is pivotal. Societal change is important, as there is need to challenge not just the issue of patriarchy, but the very notion of this perpetual consent under marriage. So the principle of equality and non-discrimination is important and it is enshrined in our constitution. This should permeate through each law of the country, including section 375 of the IPC. It is high time that India realizes that a marriage license cannot be a substitute for a woman's consent. So that is all for this editorial. Thank you so much for watching. I will see you all in my next one. Thank you.